First, I'll turn it over to our first panelist, Kenneth Townsend, who is teaching professor and director of leadership and character in the professional schools at Wake Forest Law School. So Kenneth, Dr. Townsend, thank you so much for being here.
Thank you so much, Whitney, and to everybody. It's a real pleasure and honor. Looking forward to this conversation. So I'll be presenting a slightly condensed version of my essay, Shifting Alliances and the Lost Consensus, the Religious Freedom Restoration Act at 30. Few Supreme Court opinions in recent generations have produced such swift and near universal condemnation as Employment Division v. Smith from 1990. From the Southern Baptist Convention to the ACLU, voices across the political spectrum decried the court's reversal of past precedents and mobilized to protect religious free exercise. Congress proved receptive and passed RFRA in 93 with a simple voice vote in the House and by 97-3 margin in the Senate. Upon signing RFRA into law, President Clinton declared, quote, "What RFRA basically says is that the government should be held to a very high level of proof before it interferes with someone's free exercise of religion. We believe strongly that we can never be too vigilant in this work," end quote. RFRA's honeymoon was short-lived, however. The court significantly narrowed the reach of RFRA in City of Bernie v. Flores in 97 by holding that Congress lacked the authority to impose onto states a standard for assessing religious free exercise claims. After RFRA's narrowing, religious liberty advocates began promoting state-based RFRAs to protect religious free exercise against burdens imposed by state rather than federal laws. And as of now, 21 states have passed RFRAs and 10 additional states have provided RFRA-like protections. Early state-based RFRAs encountered little opposition, but by the early 2010s, the cultural and political winds had shifted, rendering the previous religious liberty alliance fractured. Rather than being a value that united right and left, religious liberty increasingly came to be identified with conservative causes and consequently viewed with growing skepticism by political progressives. 30 years ago, the ACLU, for example, was one of the most enthusiastic supporters of religious liberty, authoring one of only 6 amicus briefs in Smith, and was an outspoken proponent of RFRA. At the Judiciary Committee hearing for RFRA, the ACLU's then president, Nadine Strawson, declared, quote, "The ACLU strongly supports RFRA because it restores religious liberty to its rightful place as a preferred value and a fundamental right within the American constitutional system," end quote. The original federal RFRA did indeed elevate religious liberty above many competing governmental objectives by declaring religious free exercise, quote, "an unalienable right," end quote, that should only be burdened, quote, "in furtherance of a compelling governmental interest," and when the governmental burden represents the least restrictive means of furthering that governmental interest, end quote. The ACLU continued to take the side of religious liberty claimants in early RFRA cases, but by the early 2010s, the ACLU had become one of the most vocal opponents of various state-based RFRAs. And in 2015, an ACLU representative wrote in the Washington Post that the organization, quote, "can no longer support the federal RFRA in its current form," end quote, citing concerns that the law too often, quote, "was used as a sword to discriminate against women, gay, and transgender people." Contemporary debates pitting religious liberty against social equality could hardly have been imagined in 93. RFRA's passage came only 7 years after the court upheld Georgia's ban on same-sex intercourse in Bowers v. Hardwick, and at a time when gay marriage, same-sex adoption, and transgender rights were not priorities of progressive organizations, much less topics of regular discussion in mainstream political discourse. It might seem unimaginable given the developments of the intervening years, but the terms LGBT or transgender appear nowhere in RFRA's legislative history, and anticipated conflict between religious liberty and gay rights merited only scant discussion. With the emergence of new countervailing demands from LGBT populations, however, religious liberty cases increasingly reflect and sometimes exacerbate social and political division. In recent years, the court has addressed, among other things, the eligibility of religious student groups to be recognized at public universities if they don't admit LGBT affirming members, a religious foster care agency's removal from a city's approved list of providers because it discriminated on LGBT status, and whether a graphic designer can be required to design wedding websites for gay couples. Some of the most contested recent religious free exercise cases in lower courts have dealt specifically with transgender rights, including cases where religious hospitals and healthcare providers refused to provide gender transition services on religious free exercise grounds. So how should we view the relationship between religious liberty and social equality? One way to approach these and other divisive cases is to reconceptualize religious liberty so as to harmonize it with other competing demands. The ACLU and other progressive organizations, such as the Human Rights Campaign and Americans United for Separation of Church and State, have lobbied in recent years for the passage of the Do No Harm Act, which, according to the ACLU, promises, quote, to restore RFRA's original intent as a protective shield for religious minorities, and would preserve the law's power to protect religious freedom while clarifying that it cannot be used to harm others, end quote. This sort of harmonizing approach promises to make religious liberty more salient, or at least less threatening for other political objectives, but there are textual, practical, and conceptual questions whether such an approach will succeed in restoring RFRA's original intent or engendering the sort of widespread agreement that led to RFRA's original passage. While it is true that Smith concerned the free exercise of a religious minority, there is nothing in the text or legislative history of RFRA that indicates the law only or primarily was meant to apply to religious minorities. It's therefore a stretch to suggest that the original intent of RFRA was limited to providing a protective shield for religious minorities, as important as that goal might be. On a practical level, this harmonizing approach will inevitably fail to win over those who prioritize religious liberty on its own terms and not simply for its usefulness in accomplishing related but nevertheless distinct objectives, such as protecting religious minorities. One of the most consequential potential impacts of the Do No Harm Act, which was first introduced in 2016, would be to make RFRA inapplicable to laws, quote, regarding the provision of or coverage for any healthcare item or service, end quote. Given ongoing controversy surrounding religious exemptions in the context of abortion and transgender rights, it's little surprise that this proposed narrowing of RFRA has faced opposition, including from religious minorities, such as the Seventh-day Adventists, who have been disproportionately represented in the nation's religious liberty case law. Beyond these practical political concerns, there are even more foundational conceptual questions regarding the relationship between fundamental values, such as religious liberty and social equality. As the title indicates, the Do No Harm Act aims for a religious liberty, social equality landscape that avoids harm. While rhetorically attractive, this aspiration is incompatible with a world where ultimate fundamental goods come into conflict. Given the realities of pluralism and the current cultural landscape, there seems no way to avoid harm or even to reach agreement on what constitutes relevant harm. The Do No Harm Act is concerned, for example, with the potential harm experienced by transgender children whose gender transitions are delayed or denied. In contrast, the newly launched Do No Harm Initiative is concerned with potential harm to children who prematurely undergo gender transition. Others are concerned about the harm experienced by medical provider or hospital required to perform services such as gender transition procedures or abortions that impose burdens on religious free exercise. To ignore the possibility, indeed the inevitability of harm, is to deny the reality of moral tragedy in pluralist societies. In reflecting on the last 30 years, it's hard not to feel a sense of longing for what has been lost. The bipartisan consensus that led unexpected allies to join in common cause has frayed, and American politics feels as polarized as ever. There are no easy answers to the polarization and antagonism characterizing American culture, including in debates on social equality and religious liberty, but despair is not inevitable. The widespread differences reflected in these debates offer reminders of just how differently some of our fellow Americans feel about issues that might seem so simple to us. If approached with a measure of humility, this recognition of deep difference can remind us of the limits of our own knowledge and prompt us to imagine the experiences of others. Such an aspiration might feel Pollyannish, but democracy requires nothing less than a citizenry willing to countenance the hopes and fears of fellow citizens. Thank you.